matters such as rookie age minimums, the drafting of foreign players, as well as the rookie wage scale. What are each of your thoughts on any of these or related draft matters?
I'll take a shot at that, Taylor, but I think the draft is always an interesting one from a collective bargaining point of view because it is a mandatory subject of bargaining that has to be covered in any collective bargaining agreement between the players and the owners. The uniqueness of the draft issues is, to a certain degree, the disparity that exists between the sports. And I think it's very interesting right now as we're all hearing about the NBA and the lockout continuing, and hopefully that the federal mediator can get some things done today toward a settlement. But the interesting thing that we have not heard about, which we heard leading up to this negotiation, was the one and done rule in the NBA. There was a lot of discussion about whether or not that would be changed, would be modified in some way. And ironically, the focus now seems to be more upon the split and less about discussions about that rookie situation. The various sports, and again, same thing that we're hearing about Major League Baseball right now, there is a lot of discussion. In fact, I'm being told from some of the people I know that the major hang-up right now, and maybe Caleb knows more than I do, but one of the major hang-ups right now is the draft, and whether or not there's going to be what we would all call slotting with specific dollar amounts, which I know Michael Weiner and the Players Association is adamant in their position of opposing from an agent's perspective. Obviously, slotting is not a good thing. But from a team's perspective, slotting would be something that would be advantageous from a predictability point of view, as well as a financial perspective. You know what you have to spend to get your players signed. So right now it's interesting. You have one sport that is almost final with a collective bargaining agreement, which I think anyone in this room who's followed professional sports would say 5 or 6 years ago, if Major League Baseball was going to be the one sport that would have a pretty peaceful negotiation from a history perspective, you'd probably say no. But I think we're all optimistic that long before December 11th, we're going to have a new collective bargaining agreement in Major League Baseball. As I said, basketball is an interesting one. In football, you have the other issue. You have to go to 3 years. So again, you have a lot of disparities that are out there pertaining to athletes and their ability to go in and start their professional careers. So I think that's one of the important distinctions is how you approach this from a collective bargaining point of view, whether or not those issues are going to be resolved in new agreements, whether that be basketball or baseball. And I would say neither of those issues is really going to be addressed in terms of changing much from what we currently have.
And I think following up on what Greg said, sticking to the NBA, there's a really interesting thing to follow right now. Will the union decertify? Will it disclaim interest? And if so, because that is certainly something that's being discussed presently, right today, the union and the NBA are meeting, and if nothing is established, if there's no progress made at the end of today, there's rumors that the NBPA, the Players Association, will either decertify, go through that process, which first they have to have 30% of the members just show interest, about 450 players. And then there has to be a formal vote where a simple majority says that they wish to decertify. If that happens, and what would happen thereafter is you would have a lawsuit filed outside of labor law, an antitrust case. And you would actually get to the point as to whether or not a draft would be a restraint of trade altogether. Because in a system where there is no collective bargaining agreement and labor law does not apply, perhaps antitrust would not allow a draft. It takes free agency, the player's ability to sign with whatever team he chooses to. It takes it out of that player's hands. So that's something to follow. If that happens, it'll really slow down the entire process. And unfortunately, it's very likely in that case that an entire season is lost.
I think to add to that, I think that's a great summary of some of the bigger issues, but one minor issue that always gets overlooked is what happens to the players that aren't protected by the union yet. You know, players coming out of college, maybe junior players that are going to declare and go early. They're not covered by the PA, in the NBA since the National Basketball Players Association, or with what I've done at the National Football League Players Association, and we saw that firsthand last year. You're dealing with a lot of players that are graduating, preparing for the draft, and either are selected and are not able to sign contracts or even negotiate their deals, but then need to maintain some level of physical readiness for when the season gets ready. And then you have undrafted players that are technically not allowed to talk to teams, but then are getting calls and dealing with issues like that. And in advising them on how to best protect their interests when, again, they're not adequately, I think, or at all represented by the union at that point. And that's not the union's fault. That's just not their charge.
And related to that, there are a lot of advocates that say, like, especially rookies, the current, unions aren't necessarily looking out for their best interest, because you think about the next rookie class that comes in the next draft are pretty much going to be taking away jobs and displacing veterans who are already part of the union. Do you really think that prospective, draftees are truly being represented at the CBA negotiating table?
I'll take a first stab at that. I think that's a tough question. I think that, again, you're dealing with individuals that aren't, they're not represented by the union at that point, technically. So the union's job is to represent current players. They do their best to represent future members, but their duty is to the current membership. And I think that in surveying the current membership, there's always a sense that the younger players are making more money than the veteran players. And I think you talk to veteran players, they're frustrated. I have a veteran client that would always make comments about playing some of the younger top picks because he was excited to play them, and give it to him a little bit because he's making half what they're making. And I think there's always that issue. But again, the union's in a tough position because the union is unable to represent folks that aren't part of its membership. So I think they do their best, but there is a rub there because you have no one looking out for the player that's coming up, in my opinion.
Yeah, I think that's the main point, that they are not part of the membership of that union at that point. And, someone like Gregg, who for many years represented baseball players, he knows as minor league players, they're not getting the same representation by the union as people on the 40-man roster. I think a great case in point is the fact, we were talking about HGH testing earlier today. Well, Major League Baseball players are not tested currently, but minor league players are. And I think the biggest reason for that is because those minor league players don't have the same representation as those MLB players. So really it gets to the point that not only are those players who are not yet rookies, but in the baseball system in particular, where there's this minor league system, those players are not adequately represented. They're not represented by this very strong union that has built up power over time.
I think the one thing too, when you analyze this, if you look at the multiple professional sports that we deal with that all have collective bargaining agreements, if you look at the NBA, for example, I think that's an interesting one. They attempted to deal with the spiraling rookie salaries and the guaranteed contracts by creating an entry-level contract. And I think a lot of people thought that was going to be the perfect ending to control rookie situations. And now you hear a lot of teams complaining about it because they put in this position under the current system where they're going out there and they're having to deal with some of their players and make these multi-year, millions and millions of dollar decisions before they really have a good sense of how great that player is going to be, or if that player is going to be a bust. The NFL situation is another interesting one again because, as the other panelists said, and same with baseball, there's really no representation model which allows the players who are drafted, unless a player is drafted in Major League Baseball and signs a Major League contract, they're going into the minor league system. They're going to be executing a standard minor league agreement, which does not include union representation. A baseball player only becomes a member of the union when they become part of the 40-man roster. So again, there's a unique distinction there. Yet, as many people have said to me, well then how does the union have the right to negotiate and have any impact on the draft when technically those players are not members of the union at the time they're drafted? And the answer to that is as long as there's one or two or a handful who sign Major League contracts, there's a relevance to the Players Association and to negotiate with regard to the issues pertaining to that draft. So that's how it becomes a very relevant issue. In the NFL, of course, as you said, which is a great point, the veteran players were really distraught because you're seeing players coming in and getting $30, $40, $50 million in guaranteed dollars, and they're out there, multiple surgeries later and 4, 5, 6 years into their career, and they're not even having a chance to come close to having a chance to secure that kind of revenue. So that was an interesting situation. I think it's a challenging one for the union because technically they have the right to represent the majority of their membership, which is veteran players, but they also have an obligation with regard to the draft to negotiate that. And I think that's why you were able to see the concessions that were made in this negotiation had a direct impact on a lot of those top draft picks.
What about retired players? What about retired players too?
That's exactly right.
All right, we're going to move on to the power of the commissioner. Notwithstanding what might otherwise be set forth in a CBA, the commissioners in each league generally reserve a right to take certain unilateral actions and make decisions for, quote, the best interests of that particular sport. This power comes from each league's respective constitution or bylaws and does not arise from the CBA. Examples of actions by commissioner utilizing this right include Commissioner Bud Selig's directive to conduct the Mitchell Report investigation regarding the use of performance-enhancing drugs in baseball. And then you often hear about Commissioner Roger Goodell's issuance of fines and suspensions against NFL players for off-field conduct. What are each of your opinions of this source of power, and how do you think CBA should address this power, if at all?
I'll start with that one, if you don't mind. I think the interesting one there, again, looking at the most recent history, which is the NFL negotiation, which was just recently completed, one of the huge issues leading up to that negotiation was this power of the commissioner. The players were, to a certain degree, I might be exaggerating, but irate by the amount of power that Goodell had in terms of really no appeal process. There's no arbitration setting that would allow them to appeal his decisions. And initially, that was supposed to be a huge issue in terms of the negotiation and collective bargaining agreement. Yet, at the end of the day, when the collective bargaining agreement was agreed to, Commissioner Goodell still retains the power that he had prior to this collective bargaining. So it's a huge issue for the players, and frankly, I was surprised that they did not address that in this collective bargaining agreement with some type of approach, because right now, Commissioner Goodell sits there as ultimately as the trier of fact, the judge, the jury, without any appellate ability of that player to have anything to say to challenge that decision or that ruling. Certainly that's a little bit different in Major League Baseball, where there is some ability to challenge some of the fines or suspensions that might be issued. There's certainly a long-established past practice of penalties that are appropriate for certain types of discipline. But I thought the NFL was an interesting one to bring up here with the power of the commissioner, because it's so recent, and I thought it was an interesting issue that the Players Association made such a big push for initially, and then ultimately, as they tried to get close to resolution, they seemed to back off from it.
And Greg, I think that's a great point. As law students, you can all probably appreciate just the right to be heard and to explain to whatever authority your position. And as Greg, I think, indicated, prior to the lockout under the old CBA rules, and now under the current CBA, the commissioner for off-the-field conduct really has sole authority. So, and that's sole authority for anything that occurs. So, just to be specific, if a player gets in a fight at a bar but isn't charged or arrested, the commissioner can still punish that player. So he's not really given an opportunity to be heard, and I think that was a big issue that players had and still have. And candidly, I don't know if it was timing to try to get the deal done or how that one made it through, but from the outset, that was a major issue for the players.
Yeah, and just to add my 2 cents, from what I've heard is that it was an issue in the very beginning, and as time went on, it was more about the split of money that sort of became one of the back issues, and it just was never really resolved. The players acquiesced, but we'll see over the next few years of this new collective bargaining agreement, what kind of power Goodell asserts. Perhaps he's not very strict with using that power for the best interest of the game. We don't really know. Was Cedric Benson one of the first examples?
Well, the Cedric Benson issue is kind of still going on, and that was an issue that during the lockout, a number of players had offenses, and Cedric Benson was kind of what was termed a multiple offender. And part of the CBA for the NFL, first-time offenders were essentially exempted out. So first-time offenders, if you failed a drug test or had issues off the field, were essentially exempted out under the new CBA. They kind of dealt away in the side letter with those issues. Now, Cedric Benson was a multiple offender, and he's got a case pending in front of the NLRB, arguing that he wasn't adequately represented in the CBA negotiations. It's a great issue because the NFLPA essentially, if you want to argue for Cedric Benson, gave away his right to appeal that offense, and now he's subject to discipline, and we're going to see how that plays itself out. But I mean, it's a great issue.
What do y'all think is going to happen with that particular case with Mr. Benson?
Well, I think the Labor Board, as we've seen, will probably take a lot of time to consider all the facts on that one. I'm not privy to all the facts on that one, but certainly the Labor Board would much rather have the collective bargaining process work and utilize that as opposed to trying to interject their way into that process. I think it was, whether his agent or someone filed that form, was probably a pretty smart move on his behalf, at least, to try and raise a flag that he was sort of caught here in the middle of these transitions between the collective bargaining agreements. But ultimately, I think that the NLRB will probably try and stay out of that if they can.